Good evening, everyone. I'm Kritika Goyal, and on behalf of LiveLaw Academy, it is my pleasure to welcome you all to this insightful session on preparation for Supreme Court of India Law Clerk-cum-Research Associate Examination 2025. We are honored to have with us Mr. Utkarsh Sonkar. Mr. Sonkar is a gold medalist from the National Law School of India University, Bangalore. From serving as a law researcher to Honorable Mr. Justice N.V. Ramanna at the Supreme Court of India, to clearing the Madhya Pradesh Judicial Services examination and serving as a civil judge, judicial magistrate in multiple districts, his experience is vast and invaluable. After his judicial tenure, he transitioned to the bar, where he now actively practices before various tribunals, high courts, and Supreme Court of India, while also contributing to the legal education through guest lectures. Today, he will be sharing his insights on how to effectively prepare for the Law Clerk cum Research Associate Examination 2025, offering valuable guidance, strategies, and first-hand experiences. Without further ado, let's welcome Mr. Utkarsh Sonkar.
Thank you so much, Kritika, for the gracious introduction. Good evening, everyone. It's a pleasure to be here. Without further ado, I will just start the topic that we have for discussion today. That is the preparation of Law Clerk cum Research Associate Examination. You would see that over the course of years, this position has become one of the most sought after positions because of the unparalleled experience that it offers to you. The moment you become a law clerk in the Supreme Court, you are usually engaged by one of the honorable judges of the Supreme Court, wherein you render direct assistance to them. However, before we begin the preparation and strategizing with respect to this examination, one question we need to answer, and that question is, why is the position of law researcher even important? Or why is it something that is sought after? After all, the honorable judges of the Supreme Court are sitting at the pinnacle of their careers. And in terms of assistance, the best legal minds of the countries are actually assisting them in the courts, being officers of the court on a daily basis. Herein, we need to understand that time and energy are two finite resources, and it is owing to paucity of these two resources that we need law researchers in the system. As of today, I went to the National Judicial Data Grid and checked the current pendency of the Honorable Supreme Court of India. It's hovering around 81,573 cases. So you would see that the daily dockets of the honorable judges has anywhere between 40 to 60 cases every day. And whenever the matters reach the apex court of the country, they have already passed through a great filtration mechanism. The matter has already been adjudicated by several forums, and only to attain a finality to that particular dispute as a matter of last resort is we have the Supreme Court of India. Thus, to take care of this issue of time and energy being finite resources and being in paucity, the law researchers play an extremely crucial role. And in terms of experience, this position provides you the most unparalleled experience in the legal domain, because straight out of your law schools, you're being associated with one of the honorable Supreme Court judges, and you get to see matters from all areas of law, be it your hardcore civil side or the criminal side, as well as the writ jurisdictions. So the special leave petition jurisdiction has been enlarged by the Supreme Court to the extent wherein most of the disputes come within the ambit of Article 136 jurisdiction. That being said, various special statutes also confer the appellate jurisdiction on the Honorable Supreme Court of India, be it our company laws, that is the appeals from National Company Law Appellate Tribunal, or under the Electricity Act, we have electricity commissions who pass various orders which are subjected to challenge before the APTEL, and thereafter the appeal goes to the Honorable Supreme Court. So just to give a few instances, everything under the sky is within the jurisdiction of the Honorable Supreme Court. So this experience for a young, fresh law graduate is absolutely unparalleled in terms of the learning curve that it offers. Apart from this, this will lay down the best foundation possible if any of you are seeking to develop a career in litigation, and acts as a foundational step even if you want to pursue your higher studies. Once you are associated with an honorable Supreme Court judge as a law researcher, you are usually preferred for higher education in particularly foreign jurisdictions. So this adds on to that. In any case, moving further after this introduction, what exactly do you need to do to prepare for the Law Clerk-cum-Research Associate examination? I am wondering that all of you must be well cognizant with the scheme for engaging law clerks that was released by the Honorable Supreme Court on its website in January 2024. It lays down the modalities of this particular examination. So the law clerk examination, just like any other examination in the country for competitive services, be it the judicial services or the public services, is put forth in a staggered format. There are three steps to this particular examination. Part one is your objective type examination, wherein you have to tick mark the MCQ questions. This is generally done in an online format these days. Subsequently, you come down to a written examination format, which is a subjective examination. On the cumulative marks that you receive in both of these examinations, that is the preliminary examination as well as the mains examination, you get marked, a merit list is drawn, and thereafter you are subjected to an interview process at the Supreme Court level after you submit your preference list for the honorable judges. So we would see what are the specific modalities of the examination in question. So the scheme for examination that I was just referring to, released in 2024, if you would come to page number 12 of that scheme, at part F, it elaborates upon the specific modalities of the examination. Herein, the first MCQ based part 1 examination consists of 100 marks. You are provided with 2.5 hours to attempt this examination. There are three components to the same. The first component is that of your English comprehension, wherein you are given a particular passage, which generally has a legal undercurrent to it. You have to examine it in detail, and thereafter you are put forth with certain questions, and you have to answer them accordingly. The second kind of question that is asked to you is specific to certain laws, and the laws which are elaborated herein are the Constitution of India. The repealed criminal laws are also a part of this, and the notification issued by the Supreme Court specifies that on the repeal laws itself you will be questioned. In any case, it does not make much of a difference because substantively the laws have maintained the same flavor. There are few crucial additions which have been made, but regardless, the content largely remains the same. So you will have to examine the Code of Criminal Procedure, the Indian Penal Code, and the Indian Evidence Act. Thereafter, you come to the law of contracts. So these are the second set of questions that may be asked to you. The third set of questions is the recent developments in the legal domain that have taken place in the preceding year. And in consideration of the fact that you are watching this YouTube live by LiveLaw Academy right now, if you are associated with LiveLaw, or if you just go through the usual updates that they keep giving on a daily basis, perhaps you must be more or less ready to attempt these questions. In any case, even the Honorable Supreme Court on its portal puts forth the list of important cases that have come up for your assistance. So you can go through them, and that will also help you in your preparation with respect to this third limb of questions that may be asked. So these are the modalities with respect to the part one of your law researcher preliminary examination. This is of 100 marks. You are, in my opinion, provided with more than enough time because this is for 2.5 hours. But then again, at the end of the day, the questions that you are asked in this particular examination are largely analytical. So you will have to apply your mind into them. Thus, my suggestion to you would be to be extremely wise in terms of the time distribution that you would be setting out for attempting this examination. Remember the kind of perks and the position that you hold as a law researcher. It's an extremely lucrative position. So, this exam by its own merit becomes extremely competitive because fresh law graduates from the entirety of the country are attempting this examination because of the experience that it provides, apart from the monetary benefits. So, this is the part one of the examination. Part two of the examination is your subjective question answering. This is a 300 mark examination. This spans over 3.5 hours. So, again, time should not be an issue. However, you would see the nature of questions which are asked to you. There are three kinds of questions, yes, again, which are asked to you. First is preparation of a brief. And in this, you will be provided with paper book of any SLP or a criminal appeal or a civil appeal or a writ petition, which may be filed in the Supreme Court. You will have to examine that paper book in its holistic detail. And then you have to come out with this brief that you will be preparing. Remember, we started this session by saying that time and energy are finite resources. And the question which you are asked in this subjective examination is a reflection of that. The honorable judges of the Supreme Court being subjected to anywhere between 40 to 60 cases on a daily cause list of an extremely voluminous record need this kind of subtle assistance. And therefore, your role becomes extremely crucial. And if you would go through the scheme of examination, one thing would become extremely clear to you that the distillation of facts and legal principles applicable, as well as brevity, are of most importance, because at the end of the day, not only do you have to be precise, you also have to be accurate at the same time. So, this is the first nature of question which is asked to you. The second nature of question asked to you is drafting of a research memo. Now, this essentially is in the nature of an opinion. Now, Supreme Court is the highest court of the country. It regularly adjudicates questions of law which are of general importance, and hence a lot of research has to go in, and certain opinions have to be distilled. And this, in a sense, has to be indicative of your legal accuracy as to whether you can accurately come to certain conclusions. So, the second nature of the question which is asked in part two is modulated in that manner. The third question, and herein certain options would be provided to you, this will be an analytical question that will be asked to you. Virtually a small essay is to be written by you on that particular topic. In fact, if I am to use a better term, instead of an essay, it should be an article in a very argumentative format, wherein you will have to develop an argument from an analytical point of view on the questions that will be asked to you. So, this is the hawk's eye view of the part one and part two of the examinations that you will be subjected to. They will be held on the same day. And these examinations being subjective with respect to the perspective of each and every candidate who would be attempting it, you will have to figure out your weaknesses and your strengths in attempting the same, as to how you have to go about your time distribution and how you will have to go about attempting the same. Now, I will go in certain greater details with respect to these examinations. So, as we discussed, that part one and part two of the examination, both of them are aimed at two things. First is your legal accuracy, and second is brevity, because time and energy are finite resources. So, with respect to your legal accuracy, there cannot be a straight-jacket formula for everyone to be legally precise. At the end of the day, each and every of you have to be very certain of the basic and fundamental principles of law. And this is actually one of the reasons you would see why fresh law graduates are preferred for this position. There can be many more seasoned people who can be apt for this position, but The reason why fresh law graduates are preferred for the position of law clerks is you have been exposed to the basics of the law immediately in the law school, and that too in the most latest manner. In a sense, chronologically, you are the closest to it because you're just graduating. So you have been exposed to the basic and the latest law. And that is why the fresh law graduates are preferred for this position. Now, a note of caution at this end. Generally, we witness a trend in the profession that whenever we interact with the fresh law graduates, they tend to emphasize and read up on a lot of latest case laws, and they would tend to develop their arguments through that. Now, it's brilliant to see kids argument framing their arguments in that manner and being articulate about it. But at the end of the day, you must remember one thing, and this is an extremely famous quote. It is Supreme Court is final, but it is not infallible, meaning thereby that Supreme Court, being the highest court of the country, gives a final decision with respect to any lists that may be prevailing in the country. But that does not mean that it is the final exposition of law on the subject. We see very frequently that Supreme Court overrules its own judgments and changes the position of law. The idea to tell you this is that whenever you are moving forward with the intricacies of your preparation, always focus on the fundamentals first. Because if the fundamentals are clear, then everything is developed on the basis of that. So in your research methodology, you must have studied the primary sources and the secondary sources. So when I began this address to you, particularly in context of seeing young law graduates referring to the latest Supreme Court judgments, the idea was to tell you that there is a misplaced emphasis on secondary sources instead of the primary sources. So my suggestion to you would be that first you must focus on the primary sources, and in that order, travel to the secondary sources. So whenever you are reading any law, there are certain first principles of law, that is the unchanging principles of any jurisprudence. Say, for instance, the principles of natural justice, the three principles of natural justice: audi alteram partem, that is right to fair hearing; speaking order, that is any order has to be recent; and nemo judex causa sua, that is no one can be a judge in their own cause. Now, these are certain first principles of law. They will never change. They are so ingrained in our jurisprudence, and our laws are developed on the basis of these first principles. So every law has the undercurrent of these basic and fundamental principles. So the idea is that first you should expose yourself to these fundamental principles. See how the law has been codified on the basis of these first principles. And this law, which then gets codified, is then interpreted by courts through their judgments. So if the chronology of your study is being on the first principles, thereafter coming to the codified law, and thereafter the exposition and interpretation of that codified law by the courts, you are bound to never make a mistake. There will be an absolute sense of legal certainty in your mind. I'll give you an example with respect to the same. There's a concept called adverse possession, and Supreme Court in the late 2010s had come up with the judgment, that is Gurudwara Sahib, wherein it ended up holding that the plea of adverse possession can only be used as a shield and cannot be taken as a positive plea to claim a relief from the court. Meaning that if I am claiming adverse possession, I cannot file a suit claiming the relief of adverse possession, that is declaration of my title on the basis of adverse possession. But if someone, say for instance, is seeking to dispossess me from the property, so if someone has filed a suit against me seeking recovery of possession, then as a defense through my written statement, I can take the shield of adverse possession, that my interest has fructified in this property by virtue of adverse possession. Now, if your first principles are sorted, a lot of people at that point of time, when the Honorable Supreme Court had come up with the Gurudwara Sahib judgment, was criticizing it, saying that this is contrary to the very fundamental principles of our jurisprudence. If someone's right has been fructified on the basis of adverse possession, obviously they should have the right to go and claim it in a court of law. And that's precisely what happened a few years later in another judgment by a three-judge bench of the Honorable Supreme Court, Ravindra Kaul Grewal. They ended up overruling this earlier position. So the idea is that the emphasis should be on the first principles, thereafter seeing the codified law and how it has thereafter been interpreted by the courts of law. So in these terms, you would see that there are certain laws which you are expected to read, on which you will be questioned in this examination, that are provided in the modalities of the scheme. And we discussed that is the constitutional law, the erstwhile repealed criminal laws, as well as the law of evidence and the law of contracts. My suggestion to you would be to go for the basic books that are on these particular laws. Don't go for the most huge commentaries, because you will never be able to finish them. The idea is to have clarity in your mind with respect to the legal principles. So say, for instance, if you are reading the Constitution of India, you can read the book by Mr. V.N. Shukla, which is a fairly big book, but not as voluminous as MP Jain. And it is something that would be manageable at your end, and you'd be able to read them. Similarly, you can read books on the other subjects so that you will have fundamental clarity on the basics of the law, because these books will tell you where the law has come from, what are the first principles of this law. They will also go into the basic codification of law that has happened after that, and how it has been interpreted by the courts of law. So once you have done reading basic books, go for the bare text of the Constitution and the bare acts for the other laws that have been asked for in this examination. And you can also read up on the latest case laws thereafter. If you move in this chronology, the fundamental clarity in your mind would be pronounced, and you will be able to attempt all the questions easily. Because as I pointed out to you in the beginning, the scheme of examination is as such that it is seeking a very analytical viewpoint from you, because judges of the Supreme Court are already seasoned in whatever they do. They already know the law. They already know how to apply it. They just want legal accuracy in the form of brevity from you. And this is why, if you know the very fundamentals of law, you will be able to assist them in the best manner possible. Going further into the part one of your examination, we discussed the three kinds of questions that may be asked to you. The first was with reference to the comprehension of language, that is English. In terms of this, your reading speed has to be pretty fast, because 2.5 hours seem a lot, but at the end of the day, when you are reading long passages, until and unless you are able to read them accurately and distill the meaning thereout, you won't be able to attempt the answers properly. So work on your reading speed as well. You can start by reading newspapers, and I have already suggested to you the basic books. And in that chronology, if you read already, there'll be a lot of reading material for you, and your speed will be taken care of. With respect to the second nature of questions that was on these particular laws, we have already discussed them. With respect to the third nature of questions, that is the recent developments, as I told you, Supreme Court itself on its website comes up with the list of case laws which are expected to be read by you. Apart from that, if you are abreast with the laws by any of the platforms, be it LiveLaw or Bar and Bench, you should be more or less sorted with respect to this. There's a caveat though, and that caveat is that part one of the examination is accompanied with negative marking. So considering the competitive nature of the examination, accuracy is preferable from your end. So try attempting as many questions as you can, so that you will be accurate when it comes to writing the final examination in real life scenario. And if you are unsure of any answer, then be very strategic of it. Do not unnecessarily tick mark that option, because you will only stand to lose out your marks in that. So be very wise with respect to it. And needless to say, your time management has to be proper so that the situation isn't such that you are unable to attempt a series of questions and lose out on a lot of free marks which you may have otherwise fetched. So this is with respect to part one of the examination. Coming to the part two of the examination. The first nature of question that may be asked to you was preparation of brief notes. You would see that the scheme of examination, which is already provided, which I was referring to, already has certain sample answers provided therein. So with respect to the first nature of question that we are discussing, you would see at page number 49 of the PDF, which is there, they have already given you a sample brief, and you would see how this sample brief is flowing down. It has a brief introduction with respect to the special leave petition that was filed. What are the brief facts which led to the list? And thereafter, it goes to the impugned judgment and finally tells you what are the grounds which are taken in the SLP. This is one of the formats which is preferable by the Supreme Court itself. But now that I have already been in that position, I will show you one of the briefs that I had prepared back in the day when I used to be a law clerk. And perhaps this may be helpful for you. This is a disposed case, mind you. So you can peruse this. You would see that we started with the brief details of the case. An aspect of delay is extremely important in the Supreme Court because if you are not coming within the law of limitation, you have to file an application for condonation of delay. So in limine, at a lot of times, a lot of petitions get dismissed because until and unless the delay is condoned, you will not be going forward and reading the file for merits. That is one aspect that you have to look for when you are preparing the brief note. And this is something that has been suggested to in the scheme of examination as well. Thereafter, you also have to look for similar or pending matters because in Supreme Court, it so happens multiple people are trying to impugn the same order. And if a coordinate bench of the Supreme Court has already decided the issue, then the present SLP becomes more or less infructuous in light of that earlier decision because it will have to move forward in the same line. Thereafter, you would see I too have given a brief backdrop as to how this SLP is emanating in the Supreme Court. Thereafter, I too have given the most material facts that are required for adjudication of the matter. Thereafter, I have provided in a tabular format the entire litigation history, how the matter has traveled to the Supreme Court, what exactly has happened. So you would see I have divided it into different columns and rows. So the three columns which are divided are clearly in terms of the particular forum. Thereafter, what exactly was the decision given by the forum and on the basis of what particular reasoning. And because you are assisting the judges of the Honorable Supreme Court, you would see that within parenthesis, we have provided the page numbers and the annexure numbers, etc., on where this particular reference can be made clearly. So say for instance, if the honorable judge wants to see how exactly the court has appreciated point number B of the reasoning, they can just flip to page number 9 because it has been highlighted by you over here, and thereafter they can go. Finally, we have come down to the SLP, what are exactly the specific grounds which are raised in the SLP and how it has come. You would see that this particular brief which I have preferred has nothing beyond the SLP. This indicates to you that this is a brief for a fresh matter. I will stop the screen share now. And we will come to discussion of the nature of matters that are actually filed in the Supreme Court and that you will be exposed to once you're working over there. The three kinds of matter that you would be exposed to in the Supreme Court would be the miscellaneous fresh matters, the fresh filing which will be coming up for hearing for the first time in the court. If court finds merit in these matters which are listed for the first time, the court ends up issuing notices wherein the other party is summoned and is asked to put forth their stance. These are called after notice matters. And special leave jurisdiction, you would see, is a special jurisdiction of the Supreme Court, wherein though no other manner of agitation of a particular litigation is provided, the Supreme Court has this power to entertain that dispute. So sometimes when a matter has to be heard on merits, if the Supreme Court eventually determines that it would have to hear the matter on merits, the Supreme Court grants you leave in that special leave after notice matters. So these get converted into final hearing matters. So the three nature of matters that you would be exposed to in the Supreme Court would be your fresh miscellaneous matters, the after notice miscellaneous matters, and finally the regular matters, that is the final hearing matters. So as of the present format in the Supreme Court running these days, on Mondays and Fridays, you have a complete miscellaneous roster. Thereafter, on Tuesdays and Wednesdays, the after notice matters are preferred, and on Thursdays, the regular final hearing matters are being taken up. So you would see in this particular format, with respect to the differing nature of cases, your note will also change. So say for instance, if you are preparing an after notice matter, so an after notice matter, a counter affidavit might be filed by the other party. So in that sense, after the SLP grounds, you can also add the counter affidavit, what has been said by the other party pursuant to notices being issued to it. So this is how your brief research note, the case note, will vary from different nature of cases. Coming to your second nature of questions, that is the drafting of research memo. This is an opinion-based question. We'll come back yet again to the scheme which is provided for. The sample answer for this nature of question, and this scheme also has the sample questions and thereafter the sample answers. Considering the limited time that I have been provided for, I'm not going into the greatest details. I'm giving you a hawk's eye view of how to prepare. So this sample answer is provided for at page number 80 of this particular scheme. You would see prominently what the researcher here has mentioned is what are the specific questions that the researcher is to address. And in light of the very specific facts of that particular case, he is going on juxtaposing the law with the facts. So when it comes to attempting these nature of questions, all of you in law school would have studied the IRAC format in your legal methods class in your first semester of trimester, whatever it may be called. So IRAC method is nothing but prominently highlighting the issue, thereafter the rule which is applicable, analysis of the facts in light of the rule which has been stated, and thereafter your conclusions on the same. That is the opinion that you would be rendering. You can modify IRAC to state FIRAC. You can just add facts at the top and thereafter the issue, which is put in question in light of those particular facts. What is the rule applicable? That rule may be statutory rule or precedential law, that is the judgments of the Honorable Supreme Court and the High Courts. Thereafter, how are you analyzing the facts with respect to that rule which you have highlighted, and then culminating your conclusions thereafter. So this is the expectation with respect to the second nature of questions that may be asked to you. So employ the FIRAC format in this, and you will be successful in doing that. Employing any other format may become quite confusing, because you would see that in our profession, everyone is seasoned to perceive things from an IRAC model. So it is advisable for you to stick to this particular model. It will fetch you the greatest number of marks. The third nature of questions in part 2 of your examination is that of analytical answer writing, wherein you will be provided very short questions and you will be given choice in that. You will have to then analytically and critically analyze whatever this particular phrase provides to you in terms of whatever you have gathered from the laws that you have read. So that's why you would see why emphasis was given on the first principles, thereafter seeing how the law has been codified in light of those first principles, and subsequently that codification has been subjected to what many interpretations and the development of law over the course of years. So this is how you ought to go about the part 1 and part 2 of your examination. Part 1 is 100 marks accompanied with negative marking. Part 2 would be 300 marks. Be very wise yet again with respect to the time distribution. Kindly do not let it be a situation wherein you are losing out on marks because you are unable to attempt the questions. Try to attempt as many questions as you can, because that will fetch you the greatest number of marks. Finally, after this particular examination, on the basis of the cumulative marks that you will be scoring in part 1 and part 2, you will be called up for interviews. And that interview may be extremely specific because every judge has a different preference. So that is something I do not wish to elaborate a lot on. The only idea is that the key pillars of being a law researcher are based on your legal accuracy and brevity. As I told you, time and energy are finite resources. So just focus on these fundamentals. If your fundamentals are sorted, regardless of the specific preferences of any honorable judge, they would be willing to let you work under them. So these are the expectations in this examination from you. And it's the unparalleled experience that you will be getting working with an honorable judge straight after your graduation. So all the very best to all of you for this preparation, and I open the floor for questions, if any.
Um, so there's one question. To catch up on recent legal developments, would the essay digest and legal roundups do?
Yes. Thank you, Kritika, for the question. You would see that most of these legal digests are prepared so as to ensure that they tread all the distance. So it is very smart that you would want to go through all of them. But then again, there may be no certainty that they would be covering the entirety of the aspects. So try to diversify your resources when it comes to the recent developments. I'm pretty sure LiveLaw will do a great job on this. Not because I'm speaking on their behalf. I've been associated with them for a very long time, so I know their digests are pretty good. Kritika would agree with me. So that would certainly be helpful, but yet again, do diversify your resources. Do we have any other questions?
I invite everyone to write in the comment section if they have any questions. We'll wait for about 5 minutes, 3-4 minutes. We'll wait for them to type out their questions.
Certainly, certainly.
There's a question, how to prepare for the third question of part 2.
Yes, that is the analytical question. So yet again, analytical question, let us take the sample question which has been asked for in the scheme of examination. The question is, the Constitution has been described as quasi-federal. Why are both centralizing and decentralizing features of the Constitution important? Substantiate your reasons with reference to specific features of the Constitution. In terms of your preparation, as I have told you, you have to stick to your first principles, thereafter see the codification of law, and thereafter its interpretation. I personally am reading this question for the first time, but on the basis of the readings that I have been done and the way I have been exposed to law, it is reminding me of Baba Sahib's very famous quote that the way our constitution is, in normal times, it has attained an extremely federal structure, but at the time of wars, it has quite a centralizing flavor to it. And the provisions of the constitution would be indicative of this. So if you would go to the provisions of emergency, you would see that whenever there's a proclamation of emergency, a lot of powers which otherwise would be exercised by the states are now being exercised by the center. So this is virtually an analysis of the center-state relations that you would be studying in your Consti 1 course in your law schools. So you will have to give a very brief description, a very crystallized format, perhaps relying upon one or two crucial articles here and there, and giving the very basic scheme of what has been provided for in the Constitution. Now, when it comes to preparation for the same, this is the reason why I emphasized on being clear with your first principles, and in light of that first principles, perceiving how the law has been codified. Whenever you read any basic book, say for instance V.N. Shukla or an M.P. Jain on it, you would see when they are dealing with the emergency provisions, they will deal with the inspirations for this source. So they will rely upon the provisions of articles of other constitutions from wherein we have been inspired, and thereafter, with the modifications that we may have chosen, we have codified the law in a particular manner. Thereafter, the very text of the constitution, how it has been interpreted by various scholars and various courts over the course of time, and as well as the literal interpretation of the same. So then you examine all of these things and then you come to your own conclusions, because it's an analytical question. No one wants you to just elaborate upon what the provision says. But constitution being an organic and living creature, how it has developed over the course of time, how has this jurisprudence developed? So first trace that jurisprudence and perhaps show how it has been developed over the course of time.
Right. I think this also answers another question, that is, how can candidates effectively present their legal arguments in response to analytical questions? But if you do have more tips on the same.
My only response to this would be the LiveLaw had told me that perhaps they'll be keeping this session for around 1.5 to 2 hours. I deliberately made it short because the very idea for becoming a law researcher is that of legal accuracy and brevity. So until and unless you can condense and have the skill of condensing a 2000, 3000 page paper book into a simple A4 sheet, this is what is expected of you. I have not elaborated on the very scheme of examination because I would want all of you to read that. So I'm not spoon feeding you with everything, but go back, read on it. They have provided, in fact, a ceiling for you guys that when you are preparing this brief synopsis, it cannot go beyond 2 pages of an A4 sheet. And this is what is expected of you. I would recommend don't even breach the 1 page threshold, because if someone has to read 2 pages, they might as well flip the paper book itself. It will become that clear through that. So be very precise, and brevity would be appreciated in this particular examination.
Right. So you can find the sample questions on the Supreme Court website itself.
Yes.
Right. Another question is that what are your top 5 book recommendations? It doesn't specify which books, but I'm assuming law books. So top 5 law book recommendations.
Very well. See, when it comes to reading law and knowing about the intricacies of the law, I can tell you all sorts of book. I mean, an HM Sirvai is kept right next to me for constitutional law. But right now, because we are having discussion on preparing for an examination, that is not the expectation from you. The expectation from you is to read the most basic book so that your fundamentals are clear. So similarly, when it comes to constitution, perhaps a VN Shukla or an MP Jain. When it comes to your contracts, perhaps an Avtar Singh. When it comes to your criminal laws, any basic book that helps you. I read Kelkar back in law school. So the idea is to read the most basic books, and then if you are confused or having questions with respect to any particular topic, then you can go on to the detailed commentaries on the same. So first clear your basics from these books that I just highlighted to you, or whatever the books you are comfortable with. It's no straitjacket that you have to read a particular book. Idea is that stick to a particular resource and clarify the basic principles in your mind and then develop on it.
Uh, there's uh, there's Deepthi asking if you can provide details about research memorandum question and how to approach them in solving those questions more effectively.
Yes.
Yeah.
So research memorandum question, Deepthi, you would see that I have already highlighted the FIRAC format to you. IRAC you must have studied in law school. I'm qualifying it with an F. So it becomes FIRAC. Basically, whenever you start any legal analysis, you have to lay down the bare material facts. And this is something that I had demonstrated through my personal law note, which I had prepared back in my day as a law researcher. So the most crucial facts that any judge would have to look into. And thereafter, what is the applicable law on that aspect? It can be a statutory provision, it can be a precedential law. So you have to be clear on that. And you would be clear on that only and only when you would have done things in a particular chronological manner that I have reiterated so many times through this address. That is the first principles, codification, and thereafter your precedential law. And thereafter, you will have to, in this FIRAC format, juxtapose these legal principles and link them to the material facts that you had elaborated upon. And the moment you do that, the conclusion will be inevitable to you. If you are very clear about the legal principles, the conclusion has to be inevitable after that. In terms of approaching the answer writing, because this is an area which becomes better with practice, it would be advisable to you if you can attempt answer writing in this particular manner. So you can go through the past year papers and see the kind of questions which have been asked. Try to attempt them and perhaps have it checked by someone who has this experience and who can assist you. I would really urge everyone to go through the scheme of examination. It is roughly around 100 pages. It's extremely elaborate. It answers mostly every question for you. So even when I was about to address you, this is the first thing I started reading. And I was so glad to read it that the things that I was doing way back in 1819 have perhaps been codified by the Supreme Court now. So it's wonderful to see that.
I think this also answers the suggestions regarding practicing writing sound briefs and memos. So you can just look at the past year question papers, practice them, get them checked. There's another question. What proportion of marks are considered when preparing the final merit? I mean, how much weightage is given to written papers and final interview in preparing final merit?
So you would see the final merit is perhaps prepared on the culmination of marks of part 1 and part 2. Part 1 is a 100-mark examination. Part 2 is a 300-mark examination. Both of them have minimum thresholds. So part 1, the minimum threshold that you require is 40% marks. And part 2, the minimum threshold that you have is 50% marks in that. So on the basis of the cumulative marks that you would be receiving in part 1 and part 2, a merit list would be drawn. And thereafter, you would be called for interviews. So I assume this perhaps answers your question. It is 1:3 ratio, if I'm to put it mathematically.
Right. This comes to the end of all the questions. If anyone has any other questions, please quickly type it out. Thank you, Shruti. Shruti says thank you very much, sir. So, yeah.
You're most welcome, Shruti.
Any other questions? We'll just give you another minute to type out your questions.
Yes, please do give them some time.
Yeah, like
I don't think so they would have expected it to end so quickly.
Absolutely. I mean, this is on an unrelated note, but I think everyone is in awe of your articulation. And someone has asked book recommendations for improving English. I think you can just touch upon that very quickly while they type.
Instead of book, I would recommend everyone to
Yes.
read newspapers. That would actually help you a lot. At the end of the day, consider yourself as a system. Whatever is the input would be the output. So if your input is really good, the output is bound to be good in that sense. So be particular about the sources that you are reading. When it comes to newspapers, I generally prefer the Indian Express and the Hindu. And when it comes to books, something like perhaps H.M. Sirvai on the constitutional law and other books by good authors that you would like.
Right. So Ketan is asking, in the first question, do we need to make a box or not? I think he's talking about the part 2, where we make a brief. Yeah.
Ketan,
Maybe to make a box.
novelty would be appreciated, I'm assuming. The sample answer which has been provided to you does not provide you that box structure.
Yeah.
I personally have preferred it always because it delineates things very cleanly. And you would see the brief which I demonstrated and showed to you was a very simple brief. It was a simple judicial magistrate order which was confirmed by the sessions judge. No, sorry, it was a sessions judge order confirmed by the High Court, and thereafter it came to the Supreme Court. So litigation history wasn't as much. There may be other cases wherein you will have at least 3 forums or perhaps 4 forums before anyone reaches the Supreme Court. So when it becomes that, it's advisable to put things in a clean, structured manner. And you would see chronologically, we had provided the litigation history. It becomes very easy which forum is doing what after that. So novelty may be appreciated.
Please correct me if I'm wrong, sir, here. So I took the exam in 2023.
Yes.
And I made a table. I'm sorry. I made a table. I made an entire table, and that's what I did. But please correct me if I'm wrong.
And Kritika cleared the examination, and thereafter she's working with LiveLaw.
Right.
So,
Yes, had the first
So it
rank.
shows to everyone the merit of making a table.
True, true. So, someone has written something which I'm unable to decode. It says that is the mental ability and the sums is I'm very weak. I think they're just trying to ask what is the importance of becoming a great advocate, or how do you become a great advocate, and what is the mental ability that is required there? I think that's what they're trying to ask.
It's very simple. I mean, as a small kid in school, everyone used to tell us practice makes a person perfect. And that's the law which is applicable throughout our life to everything. You practice anything, you become better at it. If you're practicing distraction, you'll become better at distraction. So try being as focused in whatever you are doing. And if you are giving that many hours with that degree of attention and focus to any field, after a point of time, you'll become really good at it.
So I think at this great note of motivation, we come to an end. Thank you so much for such an enlightening and informative session. I've personally enjoyed it a lot. And to all our viewers, we hope that this session has given you clarity and motivation for your preparation journey. Stay connected with LiveLaw Academy for more such insightful discussions and guidance sessions. Wishing you all the very best for your future endeavors. Have a great day.
Thank you so much, Kritika. All the very best to everyone.
Thank you.